Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a lawsuit against the President of the United States because he disclosed too much. Yeah, so the President of the United States is required, like many federal officials, to disclose certain financial liabilities as part of ethics disclosures. And someone sued the President of the United States because he disclosed too many things. So we're going to read this lawsuit and the decision from the Court of Appeals. Let's get started with this. Congress enacted the Ethics in Government Act of 1978 to increase public confidence in the federal government, demonstrate the integrity of government officials, deter conflicts of interest, deter unscrupulous persons from entering public service, and enhance the ability of citizens to judge the performance of public officials. To that end, the Ethics Act requires specified government officials and candidates for public office to periodically disclose information such as their income, gifts received, property interest, liability, real estate, and securities, transactions, positions held, and the value of qualified blind trusts. So part of these ethics disclosures require you to disclose certain liabilities that you might have that might go to your conflicts, either as it relates to pressures that might be put on to you because of your job, blackmail material, or just because you're doing things outside your employment that might interfere with your employment. So things that would make you less effective an employee. So most federal government officials have to file some version of this, and the President of the United States does too. The President must file a financial disclosure report with the Director of Office of Government Ethics by May 15th of each year. The President is required to make a full and complete statement with respect to, among other information, the identity and category of value of total liabilities owed to any creditor which exceed $10,000 at a time during the preceding calendar year. The President also must disclose liabilities owed by the President's spouse or dependent children. The requirement to disclose liabilities to your spouse or children is not unique to the President. And on a personal level, I have a bit of a problem with this. I understand the idea behind it is that we are concerned that the government official might be hiding assets by putting them in their spouse's name or their child's name. So I understand it to that advantage, but I do have some problems with it because, the spouse and children in particular are independent people. And they're not government officials. And so how is the government official supposed to know what their spouse or children are necessarily doing and what liabilities they necessarily have? So they are required to disclose things that they might not necessarily know. So what are they supposed to do? Interrogate their own spouse and their own children about their liabilities for these disclosures? I have a bit of a problem with that. You want to impose on a person who accepted a job, then I totally understand that. You want them to disclose their liabilities. I totally understand that. You want them to disclose assets that, they hid around. I totally understand that. But you want them to force, essentially, their spouse or children, who most decidedly did not sign up for any of these things, to disclose that information. It's like, one, how am I supposed to know that? Because they're independent people. And why am I required to investigate into their finances? So I understand the idea behind it, but I do have problems with it. But that is one of the requirements that apparently you're supposed to do. The regulations implementing the Ethics Act mandate each financial disclosure report must identify and include a brief description of the liabilities exceeding $10,000 owed to any creditor at any time during the reporting period and the name of the creditors to whom such liabilities are owed. So we do have this mandate from this Ethics Act that exists. And there are also some guidelines that have been issued that suggests certain liabilities that you may have to disclose and certain things you may not have to disclose. It's not part of the law, but it is part of the guidelines issued by the government ethics. So let's learn a little bit more about the guidelines. Under the heading of other liabilities that are not reportable, the 2018 guidelines instruct filers that you do not need to report the following liabilities. Liabilities of a trade or business unless you, your spouse, or dependent children is personally liable. That is, you do not include a loan owned by an LLC unless you, your spouse, or dependent children is also personally liable for the loan. So you don't have to disclose liabilities of businesses that you have. You only have to disclose your personal liabilities. So if you set up corporations, and as corporations have liabilities, that's not the same thing as your liabilities. And this goes well deep into the idea of corporate personhood, which again goes as deep as the idea of the corporation and the corporate form. The corporation is a distinct entity from the person. So the corporate liabilities are not the same thing as personal liabilities. That's why corporations were invented in the first place. These financial disclosure reports must be made available to the public upon a written application. President Trump filed his 2017 financial disclosure in May of 2018 and his 2018 financial disclosure in May of 2019. Both years, President Trump signed a form, thereby certifying the statements I've made in this report are true, correct, to the best of my knowledge. Both years, the government reviewed the reports and certified them as complying. Okay, so the president has this obligation to file this ethics report. He has filed these ethics reports. And now someone wants to sue over the ethics report. Why? Because the president disclosed too many things. Let's read on. Lovitsky filed this lawsuit alleging President Trump has violated the Ethics Act by obscuring liabilities on his reports. The key premise of the complaint is the Ethics Act requires the president to disclose only personal liabilities, that is, personal debts. Lovitsky does not allege that the president failed to include any of these personal liabilities that he was required. So he doesn't say, oh, you didn't tell us something you had to tell us. Rather, he argues that President Trump violated the act by over-disclosing. He told us too many things. That is, by listing debts on his report for financial disclosure for which he was not personally liable. For example, Lovitsky points out that in both years, President Trump disclosed a $5 million to $25 million liability owned by Amboy Bank for a mortgage on the Trump National Golf Club. But Lovitsky alleges the mortgage for the property, which he obtained on New Jersey records, states that no member or manager is liable for the debt, so President Trump cannot be personally liable. Okay, so President Trump owns some assets and owns some businesses, including a golf club. And on his ethics disclosure form, he said, my business has a liability of between $5 million and $25 million. Now, that's probably not a personal liability. New Jersey law says it's not a personal liability. But we put it on the form anyway. We didn't have to tell you about it, but we told you about it. But we did a bad thing because we told you about something we didn't have to tell you about. And that's bad. We over-disclosed. This is a problem for some reason. Let's read on. Lovitsky contends that President Trump alleged the violations of Ethics Act deprived him of an opportunity to make an independent judgment as to the integrity of the president, and of the information required to evaluate the past and former performance. Lovitsky alleges that improper disclosures will preclude him from making informed voting decisions in the 2020 presidential primary and general elections. To remedy these alleged violations, Lovitsky asked the district court to issue injunctive and mandamus-type relief, directing the president to amend his financial disclosure reports to identify his personal liabilities, along with declaratory judgment that he violated the Ethics Acts and accompanying regulations. Okay, so this guy says, I can't make an informed decision as to who to vote for president because this disclosure form tells me too many things. I have too much information. So district court, I want you to force the president of the United States to rewrite these things, to say only the things that are there by law and nothing more. Because being told more than that, I somehow cannot make an informed decision. Okay, at this point, I would point out that there is no law requiring the president of the United States to disclose his tax returns, as we've all learned many, many, many times. And a lot of people would like to do that, but apparently not Lovitsky, if we're following his logic through. The president of the United States should only tell us that what he's required to and nothing more. And if he tells us anything more than that, I can't make an informed decision. Sure, let's go with that. The Ethics Act uses the term total liabilities. Lovitsky contends the statute obviously refers to liabilities of the filer as opposed to liabilities of some unidentified third party, such as a corporation. But the text of the act does not clearly direct filers to disclose only personal liabilities, nor does the text clearly prohibit filers from listing debts for which they're not personally liable. To the contrary, the Ethics Act requires filers to report some liabilities for which they are not personally liable, such as certain debts owed by their spouse or dependent children. So the act does require you to go beyond personal liabilities by its own terms and going into spouses and dependent children's liability. So maybe some other liabilities too. It doesn't say one way or another. It just says what you have to tell us. You can obviously tell us more, so it seems. In addition, the 2016 version of the guidelines advised filers that they must report liabilities of a trade or business unrelated to the operations of the business for which the filer would not necessarily be personally liable. So the guidelines are also suggestive that this information should be disclosed. So there's that. Here, Lovitky has set up a straw man by arguing it would have been absurd for Congress to require disclosure of non-personal debts. Why? I don't know, but apparently it would be. The question before the court is whether Congress clearly forbade such disclosure, or as Lovitky frames it in his reply brief, required a differentiation. Not forbidding a filer to list liabilities beyond those required to be disclosed, or not requiring differentiation, does not render the statute nonsensical or superfluous. Given the threat of civil penalties in criminal prosecution, a cautious filer, or one with a complicated financial holding, may want to err on the side of overdisclosure. So, right, because the forms require you to disclose certain things. So a person who is of a more cautious nature might want to disclose more. If there's a borderline question, do I have to disclose this or not? And you don't disclose it, obviously people will be really, really salty that you didn't disclose it, particularly if you had to. So you could play that game, right? You could be the kind of person who goes to a lawyer and says, what is the absolute minimum I can get away with? And I don't care about being audited. I just want to win. So I want to disclose what I have to and nothing more. So you could be that kind of guy. Or you could be the kind of guy who says, this is a borderline issue, but I'm going to disclose it. And the President Trump apparently went with option number 2. Somewhat against character, according to at least some people's assessment of the president. He disclosed more than he would have to. And we want to punish someone for disclosing more things than they had to. Great. Lovitky contends that the president's certification of his financial disclosures are true, complete, and correct, and the requirement that reviewing officials take the disclosures at face value imposes an identification duty. But Lovitky provides no supports for these arguments other than his interpretation of the statute. The full and complete provision does not clearly prohibit filers from disclosing non-personal liabilities or require them to differentiate these liabilities from personal liabilities. To the contrary, particularly in view of the 2016 guide's advice to disclose some business-related debts, it provides at least plausible reason for a prudent filer to err on the side of overdisclosure if doubtful about whether liabilities of corporate entities must be reported. Finally, Lovitky argues President Trump's alleged commingling of liabilities frustrates the basic purpose of the statute because a non-personal liability of a business entity may have little or no influence on official decision-making. Well, that could be true, I suppose, but you could go exactly the other way. These businesses might have a great deal of influence on person's decision-making. Now, the ethics requirements appear not to require these disclosures because they are of legally distinct persons, which again goes to my objections to why we're requiring disclosures by spouses and dependent children, since they also are legally distinct persons. But putting that aside, there is a suggestion that you should only have to disclose your personal assets, and that is exactly what you should do. But here you went beyond that, and that's a problem because question mark, question mark, question mark. This argument, however, confronts only one stated goal of the act, deterring conflicts of interest, and ignores another, increasing public confidence in government officials and demonstrating the integrity of government officials. More fundamentally, whether the purpose of a statute are best served by requiring, permitting, or forbidding non-personal liabilities from being disclosed without differentiation is a policy judgment that requires balancing competing interests, a task best left to Congress. That said, Lovitky has identified what he perceives as a troubling gap in the ethics requirement, warning that there's no limit to the ways a creative filer could obscure his assets and liabilities by commingling them with assets and liabilities of other business, non-immediate family members, or others. At oral argument, the court posed a hypothetical situation in which a filer voluntarily reports liabilities of family members and friends to willfully obscure the debts the statute requires to be disclosed. I'm not really sure I buy that. On one level, yeah, maybe you're obscuring what you wanted, but all that information is there, and you've also told the government more than they wanted to know. So you have disclosed way more information that is now publicly available information, incidentally, because the government posts this information for the president without it being requested. So anyone can go and just download it. You don't even have to request it. It's just posted. So if you're interested, you can go through it and look at exactly what's there. And, anyone with any sort of accounting sense whatsoever should be able to tell the difference. And third-party groups can tell the difference. And who wouldn't want more information? More information is good. So yes, I suppose you could try to obscure it by telling us way more information than we wanted, but then you tell us way more information than we wanted. And that'd probably be really interesting information too. So not sure I see the problem. In response, Lovitky argues a filer who obscures information that they were required to report by disclosing more than the act requires has fundamentally not complied with the statute, even though we did, because we told you everything the statute required. All right. because Levitke has not shown there is a clear and compelling duty under the Ethics Act as interpreted for President Trump to differentiate his personal from his non-personal liabilities, the court must dismiss this action. So that is the end of our coverage of the case of Jeffrey Levitke versus Donald Trump, who was angry that Donald Trump told us more than he was required to. This was a bad thing somehow. He told us about liabilities of some of his businesses, even though he was arguably not required to. And Levitke here would like President Trump to be forced to tell us only what he's required to and nothing more. So that's a really strange complaint. And the Court of Appeals says, well, the statute says what you have to disclose. It doesn't forbid you from telling us more than that. It just says these are the things you have to tell us. So he complied with the statute. So that's kind of the end of that story. And if Congress wants something different, I'm not sure why you would, but if you do, go to Congress. So yeah, he told you everything that you need to know to be an informed voter. So go use that information if you like. And that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.